modules 2 and 3 not as very distinct modules, but modules which are going to flow into each other. So when we talk about rights and when we talk about property in Indian context, it's impossible not to also refer to the debate around constitutional amendments. Those two really are going together for us. So when we look at constitutional amendments and how other countries have different processes of amendment, and if the idea is that when whichever body, whether it is the Legislative Assembly, and in the context of Ireland we'll be discussing is the referendum process, it doesn't matter how the amendment happens, isn't it? Because amendments always happen in terms of reflecting the will of the people. Amendments don't happen in the context of any other mechanism by which constitutions can be altered. Constitutions are largely altered. The debate that we are looking at right now is the alteration of constitution by popular will. And once that exercise has been entered into, is it possible, and how is it possible for the judiciary to then evaluate that expression of the will of the people? To what extent does the judiciary have a legitimacy in examining that will of the people? And this is where we are asking you to look at whether this dilemma of the judiciary engaging with the manifestation of the people's will in terms of constitutional amendment is a question of the role of the judiciary? Is it a question of what judges must be doing and what judges ought not to be doing? So is it largely a question of judicial self-restraint, if you want to call it that? Or is it a question of interpreting the text of the Constitution, and when the Constitution doesn't permit for something, it doesn't permit for something, it doesn't matter, and so that there, in that context, the role of the judiciary is not relevant, because the judges are doing what they should be doing, which is that they're reading the text of the Constitution and interpreting the Constitution the way in which it ought to be interpreted. So then it doesn't become a question of anything other than constitutional interpretation. And in this process of constitutional interpretation, how much do judges rely on ideas of spirit and identity? And can you use spirit and identity against the expression of the will of the people? And this is really the question, that what is the spirit of the Constitution, and at what date is the spirit of the Constitution, and what is the date that the latest amendment to the Constitution is being proposed by a majority, whether it is in terms of a referendum, whether it is in terms of a constitutional amendment that is passed by Parliament. Why should this not be a reflection of the will of the people or the identity of the Constitution, and why should the identity of the Constitution only be understood in terms of a particular time in which the Constitution comes and not much later? So this is the question, and it is really wonderful to have a judge himself explain this process to us. And here again, we have deliberately left out the Indian references, and so given that all of you are familiar at least with the debates around basic structure, even if you don't know the entirety, you're familiar with the debates around basic structure, we are hoping that you will be able to make the connects in following the lecture, that once we've had a lecture on seeing how this idea plays itself out in a different constitution, to what extent would that jurisprudence be relevant to us? And this is why I think all of you should pay close attention. We're so used to referring to judgments of certain jurisdictions as if they are authoritative. But and the real problem is to look at the jurisdiction that we have not really so far used. And the dangers of using this jurisdiction are going to be demonstrated to you very clearly, and I hope you will be able to pick out on those aspects of what is the hazard of using constitutional material from other constitutions, and then make the reference to the Indian Constitution once we are done with the lecture. Okay? Thank you.
Good morning, everybody. Can Can my friends up in the back hear me? Put your hands up if you can. Yeah. Okay, we're loud and clear. The issue of judicial activism is a prominent feature now in almost every democracy. It's one of the hot topics. It's a hot topic in the United States, in India, in Ireland, and in Europe, as we discussed yesterday. Every judiciary is fixed with the power to adjudicate issues, but not all judiciaries have the power to adjudicate and review the constitutionality of measures passed by the legislature. The practice of judicial review, as we know, is particularly important in the area of human rights because it is the method whereby the courts protect and vindicate the human rights of individuals. I don't think that's my phone. The courts in many democracies play a pivotal role in protecting values such as life and liberty, equality, privacy, freedom of expression. And if you want to see an interesting article which may touch on some of these issues, there is an article called Guardians of the Constitution, Unconstitutional Constitutional Norms by O'Connell, 1999, Ford Journal of Civil Liberties, 48 to 75. It deals in great detail with the question of judicial review, and in particular the judicial review in the context of what we're dealing with today. The issue we're dealing with today is twofold. On the one hand, we're dealing with the right of property, but also we're dealing with the right of property in a particular context. That is the context of what are called unconstitutional constitutional amendments. We have, in many courts, in many jurisdictions, courts have entrenched powers to protect constitutions. But here the issue of interpretation becomes even more important. To what extent can the courts interpret a constitutional amendment to the extent that actually they hold it's unlawful, unconstitutional? And I know that you're familiar with the Indian jurisprudence on this issue, but to a common lawyer it still poses a paradox. How can an amendment to a constitution actually itself be unconstitutional if it's procedurally correct? So, furthermore, it raises another issue. To what law does a court have resort when it's holding that a constitutional amendment is unconstitutional? Is there some law beyond constitutions? Who writes that law? Who thinks it up? Does it belong to some group? Does it belong to some religion? For example, if from my own country, courts had resort to what was called natural law, which was from a Roman Catholic background and context. But how did that make people from other faiths feel when a doctrine was used and a philosophy was used which came from one faith, while at the same time purporting to protect and vindicate the values of all faiths under a constitution? So if we take three countries, Germany, India, and Ireland, they all allow for judicial review of statutes. And you see, they have, in the German case, Germany has a series of provisions in their constitution, Articles 1, 20 and 79, which in particular are of interest because in textual form they actually protect entrenchment. They deal with issues such as freedom, deal with issues such as dignity, deal with issues such as federation. Why is that? Because what happened in Germany in 1933 was that Hitler gained power not by a putsch, but by democracy. And by resorting to what is called the tactic of legality during the 1930s, the Weimar Constitution, which was the German constitution enacted in 1939, was shown to have an Achilles heel. It could not be protected. It was capable of an amendment. And because it was capable of easy amendment, Hitler was able to change the shape and dimensions of Irish society, of German society, from a democracy, although a frail one, into a dictatorship. So the issue is, to what extent should constitutions contain within them a device for their own protection? There are different procedures for constitutional amendments. In Germany, the question of an unconstitutional constitutional amendment has hardly ever arisen. It was touched on in one case, but they never made, the German Federal Constitutional Court never reached a conclusion on the issue. In Ireland, the procedure is different because we have a referendum of the people, so that when we want to amend our constitution, there is a proposal put through Parliament in the form of a bill, and that bill is then presented to the people, and the people vote on it in referendum. And we will discuss later the procedure which we have for dealing with this referendum process, because as we will see, all courts, constitutional courts, play a role in protecting and vindicating the values contained in constitutions, but in different ways. The Indian Supreme Court, as we well know, from 1973 to 1980 in the course of judgments, dealt with the question of unconstitutional constitutional amendments. In a different way, the Irish courts deal with referendums, because as we'll see, we have a procedure in Ireland whereby once a proposal is put to the people, thereafter the government is not permitted under our law to use state assets or resources to advocate a particular position in the referendum. Thus, the people, with the capital P, are to be constituted as the judges. And why that's particularly important in Ireland is that certain issues come before the people regarding whether or not issues and measures are necessary for Ireland's continued membership of the European Union. It is generally acknowledged that as we have already discussed, constitutions are not to be seen as a series of isolated clauses, but rather to be seen holistically. Sometimes, rather than dealing with every constitution on an equivalent basis, courts will look at a hierarchy of values, or, as in the case of India, will look at particular groups, golden triangle, of rights which are enumerated and identified under the Constitution. But in Germany, in the Constitution of 1949, there is specific textual authority for limits to a constitutional amendment. And that's in modern times, that's one of the indicators of an entrenchment of certain provisions. But the question arises, what are these super-positive norms? These are norms that go beyond positive law. Do they emanate from some concept of natural justice? A secular natural justice? Where does that natural justice come from? And the German courts have touched on this, as I said, but not actually decided it. But what's important is they have the specific textual power to do it. Now, I want to deal with the Ireland-India connection in a little more detail, because the question is, in what circumstances can courts judicially review a constitutional amendment? And that question arose in an acute form in Ireland in the late 1920s and early 1930s. Just to give you a little bit of context, in Ireland, it arose in the context of the 1922 Constitution. And if I just pause there, that was the Constitution which was entered into between the Republic of Ireland, that is the 26 counties, and Britain after the War of Independence. It contained an amending power. And what happened was that on a series of occasions during the 1920s, that very amending powers was itself amended so as to extend the period of the amending power. Thus, the Constitution of Ireland of 1922 contained the same Achilles heel as the German Weimar Constitution of 1919. The legislation which was introduced was, and which came into question in the case of the state Ryan versus Lennon, was remarkable in its nature. It was draconian. It allowed for military courts. It allowed for military courts to try people on criminal offences. And in particular, it allowed those military courts to, if necessary, sentence people to death. And this arose in the context of continued operations by the IRA in the late 1920s and early 1930s. While a treaty arrangement had been arrived at between Ireland and Britain, the truth of the matter was that there were still many who were opposed to the treaty. And the question then arose as to whether the state was entitled to enact this amendment, this draconian legislation. Was it entitled to do it in the form of an amendment to the Constitution? And what happened was that a challenge was brought to the legislation, which was set out in the 1922 Constitution. And if we go then to the challenge, the Article 2A as the Chief Justice Kennedy explained, gave permanently to the Executive Council, that is the government, for the time being to put the new article into operation at any time and to supersede a great part of the Constitution whenever and for so long a time as it finds it expedient to do so. So the question was, could that possibly be constitutional? Because effectively the amendment had the effect of abrogating the Constitution. And the chasm between the positivist textual approach of the majority of two and the minority of one was one which, as we see, was precisely the same as arose in Indian jurisprudence in the 1970s. So far as the majority were concerned, they looked at the Irish Free State Constitution. They said it was to be, as we will observe, an important point, that it was still it was a constitution which still preserves the position of the Crown. Thus, the people were not sovereign. And why is that important? Because, as we will later see, the Constitution, this case was cited in Indian jurisprudence, but as we will also see, it was cited in a manner which did not advert fully to the legal context. In particular, when the Indian courts came to consider the state Ryan versus Lennon, they did not advert to the fact that the constitution they were considering, that is the Irish Constitution of 1922, was not the constitution of a sovereign people. By distinction, the Constitution of 1937, which had superseded it, and by the time of the Indian case law was well in force, was not adverted to at all. So the positivist approach was, it's the law, it can be amended by law, and Mr. Justice Fitzgibbon said that it can never be said that the Sayers thought that's the Free State has obtained citizens by false pretenses, and it can be promulgated urbi et orbi, that's to the whole world, that's to the range of people, the Czechoslovak and Mexican and our kinsmen in the United States, that the Constitution is capable of this kind of thing. It was a very, very sardonic judgment, because what he was effectively doing, Fitzgibbon was saying, I don't like what I have to do, but it seems to me, because I am a textualist, that is the law, and therefore, even though it's draconian legislation, it's capable of being upheld. He was supported in that by another judge, Mr. Justice Murnaghan. Against this, there was another judgment. And if you just look at the majority judgment again, Mr. Justice Fitzgibbon, he said that the amendment was an integral part of the Constitution, setting forth in the clearest language, in the forefront of that document, the conditions under which liberty is enjoyed and justice may be administered in this other Eden, demi-paradise, this precious shore, stone set in the silver sea, this blessed plot, this earth, this realm, this Serstat. That's a quote from Shakespeare. And I'm going to give a special prize, because I can't find it, and I know it's there, but there's a prize by the end of the week, because that precise quotation was cited in one of the one of the Indian cases of the 1970s, where that passage was actually referred to by one of the judges, but referring to India as being the blessed country. And if you can find it, as I know it's there, there's a special prize. I'm not sure what the nature of the prize is. It might be cash. It might, on the other hand, be something less obvious. In any case, the minority judgment of Mr. Chief Justice Kennedy is something to look at. He was one of the drafters of the 1922 Constitution. He became Attorney General, then he became the Chief Justice. And his judgment is influential because what it did was it rejected the idea of textualism. And he said that there is a law beyond the Constitution. And he said that, if you can see there, it's no mere amendment, but affects a radical alteration of the basic scheme and principles of the Constitution. Does that phrase sound a little bit familiar? Basic scheme, basic structure, just a little bit familiar. Now, of course, it's not that Chief Justice Kennedy invented the basic structure principle, but it was exactly the same conceptualization. What he was effectively saying is that the amendment had the effect of superseding a greater part of the Constitution, and that effectively, to use a phrase from later Indian jurisprudence, it eviscerated it. So it was precisely the same situation in some ways that faced the Indian Supreme Court in the 1970s. If we go on to the next file, if we go then to the next quotation from Chief Justice Kennedy, where he refers to, no, just leave that one for the moment, thanks. Look where he says there, the Constitution is the fundamental structure upon which the state was set up by the third Dáil Éireann, that's our Parliament, sitting as a constituent assembly. And if you actually think about two of those terms, first of all, fundamental structure, and second, constituent assembly, you begin to see the remarkable echoes between the issues before the Indian Supreme Court in the 1970s and what Chief Justice Kennedy was talking about. That's not to say that we in Ireland invented the issue at all, as we'll go on to see later on. But it does illustrate the tension which exists and which judges have to face in many jurisdictions when faced with something which they consider outrageous, when faced with a challenge to the values which are actually embodied in the Constitution itself. So what happened afterwards is that the Public Safety Act was put into effect, and 2 years later, in 1937, a new constitution was introduced by Mr. De Valera, who took great care to ensure that it was not capable of amendment in that way. It is rigid as compared to the flexible constitution of 1922. It allowed only for amendment by way of referendum put to the people, and to date there have been 33 constitutional amendments, rather fewer, I think, than there have been in India. The organisation of a referendum in Ireland is a big thing. It's carried out in a solemn way because the people are thereby constituted as legislators. And as we will see later on, the courts in Ireland have taken care to ensure that as the people are acting as legislators and judges, that they are protected from improper influences. So if we go on then to the next slide, in Ireland, because I'm going to touch on Ireland as an example, the resort was made to a concept of natural law. And the judges in and Chief Justice Kennedy in 1935 said effectively resorted to natural law in seeking to protect the values inherent in the Constitution. During that period, natural law was seen as something very immutable and a product of Roman Catholic doctrine, and in particular St. Thomas Aquinas. It is said to have been the product of reason, and that by resorting to reason, the precepts of natural law could be established. But the difficulty about it was that the natural law principle entirely reflected Roman Catholic teaching. Now, Catholicism changed in the 1950s and 1960s, and it became more outward-looking, and eventually this message came to Ireland at a time when a whole new generation of people had come up who were far more outward-looking and far less entrenched in old attitudes. And in the 1960s, in a case called Ryan versus Attorney General, one High Court judge, Mr. Justice Kenny, made a remarkable decision, an epoch-making decision, where he held that as well as there being enumerated rights in the Constitution, there were unenumerated rights in the Constitution. And he enumerated or identified the right of bodily integrity. The case arose in the context of the remarkable, as many important cases do, arose in the context of whether or not there could be fluoridation in the water supply. You might think it's a fairly unimportant issue. It took days in the High Court. Scientific evidence was called from the United States, from all over Europe, and the issue which had to be decided was, did this impinge on Mrs. Ryan's right to bodily integrity? And the Supreme Court said yes, that was a right which could be recognized. Bodily integrity was something which felt conveniently within the idea of natural law. But in the United States in the 1960s, other developments were taking place, and there were contacts between our courts and the United States courts. And in 1965, the case of Griswold versus Connecticut was decided in the United States, which which struck down a Connecticut statute which prohibited the use of contraceptives. So privacy was that also an unenumerated right. So in 1973, Mrs. McGee, who was a married woman, brought proceedings to the High Court and then the Supreme Court, contending that if she was denied the right to use contraceptives, her health, not only her health would be put at risk, but there was a real risk that she would die. There was medical evidence to entirely substantiate that, and the Supreme Court, Mr. Justice Walsh, delivered a judgment holding that as well as there being an unenumerated right of bodily integrity, there was an unenumerated right of privacy. But the difficulty about this was it was confined to marital privacy, and it took another 20-odd years for the idea to percolate through that privacy in this context should be seen as autonomy for women. It took some considerable time and a great deal of legislation. But the difficulty was, for the natural lawyers, that what had followed on from Griswold versus Connecticut was Roe versus Wade, which again relied on the principle of privacy. And the concern that the natural law adherents felt in Ireland was, well, if we have decided McGee relying on marital privacy, could that also be the same principle applied logically in the context of abortion? So the net result of this, as I discussed with some of you during our great dinners, was that an amendment was put in place in 1983 which sought to forestall this possibility. And it recognized, it was the 8th Amendment to the Constitution, and it recognized the right to life of the unborn. I'm using that term, quoting it, in the context of the equal right to life of the mother. And the important thing to note was, so far as the Catholic Church was concerned, that was an embodiment in the Constitution of natural law. It was strongly opposed by minority faiths and others who contended that this was actually the placing in a constitution of a sectarian piece of legislation. So the constitutional amendment of 1983 was passed by approximately a 2/3 majority. Ireland was then still a very conservative country. It's now a very radically different place. And later on, there was a case, as we just see referred to at the bottom there, Attorney General versus X, 1992, in the case of a young girl who was raped, and the question was whether or not she could travel to England for an abortion. The Attorney General of the day applied for an injunction to the High Court to prevent her from travelling, and ultimately it was decided in the High Court against the girl applying the Constitution, but ultimately the Supreme Court held that on a proper application of the law, the fact that the girl was threatening suicide made it an exception, and that her right to life was placed at risk. As a result, she was permitted to travel to England for an abortion. The issue, of course, didn't end there, because there were every year many women travelled to England for abortions. The statistics were around about 5,000 a year at that time. So thereafter, there were other pieces of, if we look at the Attorney General versus X, you see there that it dealt with the unenumerated rights, but those unenumerated rights did not establish the superiority of natural law over the Constitution, and that there were rights which should be reasonably implied amongst the unenumerated rights guaranteed by the Constitution. It mentioned extra-textual values and looked at the preamble to the Constitution, which referred to justice, prudence and charity, and indicated that rights do not override the Constitution. The judgment took place, be it said, in the midst of a huge outcry, public outcry from women's groups and the public, civil society generally, I think it's fair to say, because it pinpointed one of the problems that people had, those who opposed the referendum had sought to identify. That is to say that they said it might lead to unforeseen and unforeseeable outcomes. And later on, there were a series of other judgments in relation to the Eighth Amendment and regarding the right to travel to England. So if we move on to the question of the next slide, and we travelled then on to the general power of amendment of the Constitution, which was embodied in the Eighth Amendment. So our Constitution is different from the Indian Constitution in that it allows for and only allows for referendums to amend the Constitution. And if you look at the records of the Constituent Assembly, you will see that this was a conscious decision by Nehru, made in an Indian context, just on several bases, pragmatic bases. Number one, that it would be difficult enough to hold an election in India, vast as it was, but to hold referendums would have been asking a very great deal. And second, I think that referendums carry with them, or sometimes contain, complex legal material, and while it would be easy enough, and was easy enough, to organize the elections as they were organized, to organize referendums every time a legislative proposal came along would be very difficult. So our Constitution allows that for an amendment, whether by way of variation, addition or repeal. And those words are also interesting, because if you look at the jurisprudence of the legislation, the emergency legislation brought in by Indira Gandhi's government in the late 1970s, that was precisely the form of words used so as to forestall the basic structure doctrine which had been identified by the Indian Supreme Court. Precisely the same words. So again, echoes. We see that in Ireland, the legislative process is effectively non-justiciable. That is to say that our courts will not interfere with our legislature when they're dealing with a constitutional amendment. And the only way in which there can be a judicial interference with legislation is in the context of what is called an Article 26 referendum. If a matter is passed through the Dáil by way of legislation, and there is a serious doubt regarding its constitutionality, there is a power under our Constitution to refer that matter, the bill in its entirety, to the Supreme Court to determine its validity or invalidity. And we are not allowed to say we don't know. We have to say either yes or no. And that involves a very complex procedure carried out under great pressure, because it must be done, the decision must be done within 90 days. What we do is we assign counsel for one side and the other, and those who are challenging the constitutionality of the legislation have to consider all the various hypotheses or contexts in which the bill or sections of it may be unconstitutional. And thereafter, during the course of the argument, counsel for the state will respond to that. Thereafter, the court issues its judgment, and until 3 years ago, the court only delivered one judgment on the issue, but that law has now been changed. Just one other issue. It's worth touching on Roach versus Ireland, because it's of interest, because later on, the Supreme Court, just before I came onto it, had to deal with the issue of the preservation of human eggs. And the question, it's an indication of how far things have moved on in Ireland in the last few years. And the court had to face the question as to whether or not the father and the husband having died, the mother was entitled to use eggs which had been left there in a clinic. And the court considered that the eggs, which were fertilized eggs, could be destroyed. And now that's a very considerable jump from the principled position of Roman Catholicism, which considers that from beginning of life, from very conception onwards, that life should be protected. So effectively, what has happened in Ireland is that from the 1980s up to now, the idea of natural law has receded, and in 1995 the Supreme Court explicitly said that the only law to be found was in the Constitution itself and not natural law. So let's go on then to dealing with how we protect the referendum, because you in India here, as we've discussed at length, the protectors and guardians of the Constitution have been the Supreme Court of India, and have looked carefully at whether or not the amendments proposed offended against the basic structure. And why this knits in with the question of property, as we already have touched on, is that so many of the amendments which were proposed, the sharp edge amendments proposed in the late 60s and early 70s, which gave rise to basic structure, were property related amendments. And they related to whether or not the government of the day could introduce legislation which impinged or limited property rights. So what's the position in Ireland? Well, the referendum, as I say, can go through the Dáil, that's our legislature, and thereafter it's put to the people in the form of a proposal on which the people can vote. There is a Referendum Commission which has the job of ensuring that the arguments both sides are presented fairly, and it ensures that the proponents and adherents of the proposal are given equal airtime. There are decisions of our court which say that there has to be equal airtime on the TV and media, and also in a judgment called McKenna, which we will see, our court also pronounced that the government was not permitted to expend monies advocating a proposal which was put forward, even though it was the government itself which was putting forward this proposal. And this meant that not only was the government not allowed to expend monies on advertising, state monies on advertising campaigns, but even civil servants were not permitted to engage in advocacy work once the Constitution campaign had been launched. It was much criticized, the decision. It remains the law, and it embodies the way in which we, our Supreme Court, see ourselves as the guardians of our Constitution and protecting the right of the people as the ultimate legislators, the sovereign legislators, to make decisions in a manner which is unaffected by overweening pressure. And if we look at, if we go back to Hannafin just for a moment, yeah. In the case called Hannafin, which you see referred to there, Chief Justice Hamilton said that no organ of state is entitled to review or interfere with the will of the people as expressed in their votes cast in a referendum, to consider a proposal for the amendment of their Constitution, because the will of the people as so expressed is binding on all organs of the state. So what the Constitution does, as expressed in our judgments, is it effectively creates the people as the sovereign legislators. And thereafter, in a case called, if we look at McKenna, there was, if we look at McChrystal, a challenge was brought to a constitutional amendment relating to the position of the welfare. If you remember, we were talking before about the welfare principle for children, and in particular the question of the position of the family under the Irish Constitution. A few years before this referendum, I had to decide a case which concerned adoption law. It concerned two parents who had a child, but they were not married, and they were very young. The child, they put the child up for adoption, and if everyone wouldn't mind just making sure their phones don't go too near the mics, because it makes life a bit hard. But they placed the child for adoption, and a year later the young parents got married, as a result of which they were a family under the Constitution. And they reflected on having reflected on the situation, they said, we would like to have the child back. The other side of the equation was that the child had been placed with adopters. Not all the paperwork had been completed, but there was strong evidence that the child had bonded with the adopters. And the evidence was that if the child was moved back, it could inflict serious damage on the child's psychological welfare in the light of the bonding having taken place. But there was law, considerable case law, which said no, that in circumstances such as this, the position of the family had to be vindicated, and if a family had a prior and primary right to the custody of their child, unless there was evidence of a failure of parental duty. Now, I held that in the circumstances the child should remain with the adopters because of the evidence. The Supreme Court, however, applying established case law, said and held, no, that was incorrect, because the case law established that, and the Constitution stipulated that the position of the family was primary, and that the issue of welfare should be determined in the context of the family as identified under the Constitution. So there was a lot of concern about that judgment, and there were other issues which gave rise to the introduction of a referendum on the position of children, allowing married couples to place their child for adoption, and also ensuring that in all decisions made regarding children, that welfare would be the primary principle. That proposal was put to the people. It was passed, but a challenge was brought to the referendum, saying that government officials had issued documentation and had engaged in advocacy and propaganda work. And the Supreme Court, before my time on the Supreme Court, held that the presentation of images and slogans are attempts to frame the debate in terms favorable to one side. It's a common observation that a person who is able to frame the debate, particularly if they put themselves in a trusted position as the purveyors of information, will often succeed. So as a result, the question arose as to whether or not it could be shown that the actions of the government had materially affected the outcome of the referendum. Fortunately for the government, the matter was rested there so far as Mr. McChrystal was concerned. Another challenge was brought by a person called Jordan, who brought political scientists from England in an effort to show that the relatively slim majority of the referendum could have been materially affected by the government actions. However, the evidence was non-coercive. The High Court held that it was unpersuaded by this, and we upheld the decision. So, if we move on to the next slide. Just going back to India, I want to talk a little bit again about basic structure. The basic structure notion is actually quite old, and if you look at there's a tremendous thing on the internet. It's a PhD thesis by a guy called Novai, N-O-V-A-I-Y, Novai, and it's called Unconstitutional Constitutional Amendments. And it tells you everything you want to know about unconstitutional constitutional amendments. It's a brilliant piece of work, and it was subsequently published as a book by the Oxford University Press in 2017. And he deals not only with unconstitutional constitutional amendments, but also the migration process, which touches so closely on the question of comparative jurisprudence that we've been discussing. So what he does is he outlines the history of entrenched provisions and constitutions going back to the British political philosopher John Locke in the 17th century. He says that there were such provisions in the Pennsylvania Charter of 1701, in Norway in 1814 there was a basic structure doctrine. In Mexico there was a position entrenching the position of the Holy Roman Catholic Church as being a structural part of their constitution. And if we go on then to, if we come back to that rather nice slide which we were about to go to, you'll find similar provisions not only in Mexico but throughout the 1830s and 40s in a vast number of South American constitutions. You'll find it there, as we had mentioned earlier, in the German Constitution of 1949. You find it in all of those South American countries. and you find it in the Central African Republic, Mauritania, and indeed even in the United States, where there was apparently what is said to be an entrenched provision regarding when the abolition of slavery might take place. If we go on to the next one. The following Casavananda, the essential features were decided, as we know, on a case-by-case basis. We know what happened in Indira Gandhi's case, which affirmed the basic structure doctrine. We know that it was finally confirmed in Minerva Mills. But just as I spoke yesterday in relation to the principles of social policy, the judgment of the Indian Supreme Court in relation to the question of fundamental structure grew legs. It flew, and it's flown to a vast number of other countries. So it demonstrates the extent to which all these ideas which are carried in constitutions migrate from one place to another. So I think we've already been through those provisions, but you will find, among other places, that the basic structure doctrine migrated to Bangladesh, to Pakistan, to Tanzania. It was considered in other African countries. It was rejected in Sri Lanka. It was rejected in Singapore. But as a principle, it has now gained currency, and it is one of the hottest topics in international constitutional law. So you see those countries, in some it was touched on, as just as Albie Sachs in South Africa referred to it in scholarly article. It was dealt with in a case in Tanzania, and you see that it's gained currency, not total acceptance, but currency in a vast number of other countries. And that's entirely as a result of, if you just think back, the happenstance in one lecture in 1965. Now, I don't erect a huge theory out of this, because there is no doubt that nowadays there is a huge contribution made by academic commentary to the migration of ideas. But what I question is the extent to which we can impose some kind of concrete iron law as to the processes whereby this carries out, and in particular whether convenient labels can be put on it other than one by Mark Tushnet, which is called bricolage, B-R-I-C-O-L-A-G-E. And bricolage effectively means using things which come to hand. And Tushnet's thesis, which I think has a fair bit of evidence to support it, is that among other ways, bricolage is one of the ways in which constitutional ideas migrate. So I think what we've talked about today, and I'm sorry for going a little bit slowly through it rather than talking fast, but it deserves consideration in really rather more deeply than one might think in the first place, because what we have here is, as said there, a great concept taking wings. And it took wings as a result of the judgment of your Supreme Court. And it shows, I think, a number of things. The value of the connection between comparative law and practical law, the occasional contingent flow of influence from Conrad to the council, who was in the case, to Minerva, and so on ad infinitum. And if you want to read more about it, as I say, you'll see a great deal set out in Mr. Novi's book. I don't want to take any more of your time, but it seems to me that the issues which we have to talk about are, to what extent can we say that there are values beyond the Constitution? What are those values? Who identifies those values? Do those values have dangers as well as benefits? For example, if we identify values beyond the Constitution, are we running the risk of constituting ourselves as judges, as philosopher kings, who can determine almost anything? Or what limits do we put to the way in which judges can resort to law beyond the law, or can deal with the question of unconstitutional constitutional amendments? I know this has been a rather slow, tedious kind of lecture, but I felt it was important that we deal with it in a rather more detailed way than hitherto. Thank you very much for your attention.
I think some of the students here who are sitting here for the first time, and we have the LLM students as well who are sitting in on this, have had an opportunity of looking at these methods in a little more detail than perhaps the others have. So the idea of bricolage or expressivism, functionalism is something that we have done with them in some amount of detail. And so perhaps it would be important for them to also engage with this question that the speakers ended with. When we're looking at the values of a constitution, are we looking at values beyond the constitution? And what is the justification we can offer for looking at values beyond constitutions? That's the first question. But I think during the course of the lecture, there were a couple of other important questions which I'd like to flag out, and I hope that students will be able to respond to it. One is the express rejection of natural law in spite of explicit textual references to a certain idea that is emanating from natural law. Yeah. So those of you who had the text of the Irish Constitution given to you, and we've had questions pointed out about the preamble of the Constitution. Now, in spite of such explicit textual references, how is it possible for a court to interpret that as being not moving beyond the Constitution? And how do they feel that, how is it possible, how do we understand this interpretation that then natural law is not a part of the Constitution, and that they can actually interpret the Constitution without reference to natural law? And so I thought this is, so are we saying that when the court is doing this, it is moving beyond the text of the Constitution and it is actually not giving effect to the text of the Constitution, or is there an alternative view to that? The second question is of course related to this, which is that when you have rejected the idea of natural law and you're saying you locate the law in the Constitution, is it as simple as that? Can we simply say, yes, we need to locate the law in the Constitution, but then how exactly, when we're saying locate the law in the Constitution, are we referring to constitutional text? And if you cannot refer something to the constitutional text, does it mean then that in that country that doesn't exist? And it's tied to the earlier question. So you have a particular idea of what the law is in the Constitution and you interpret it differently, and then you actually state that you need to locate the law in the Constitution. So how do you see these as conflicting paradigms, or are you able to harmonize both ideas, is what I want you to think about. When we say that, and if we have ended with the idea of bricolage, or actually cherry picking as it is also known, that it's a very random exercise. That the first thing that the judge finds or likes or finds useful is what they use, and so are they really, should academicians and scholars really bother with this whole exercise when it seems to be an exercise in randomness? And that is something that I thought, why is it relevant for us as students of law to look at this entire process when you do not find a coherent way in which judges seem to be using comparative law? When you don't see that coherence, what does it mean for us? Should we simply accept it and say, yes, that is the way in which the judicial process works, and it is of no significance to us, or how would you want to look at this? So I thought I should flag out these questions, and I'm looking forward to hearing from you.
I had a question of a slightly different nature. So I was looking So the way I was understanding, the way I understood how amendments work in the Irish setup and how they work in India, I understood that there is a referendum that happened every time an amendment is suggested in Ireland. Whereas in India, so the kind of development that the law has seen with respect to constitutional amendments, to my mind, is that any amendment is not seen act of the Constituent Assembly per se. It is not a typical ordinary legislative act, but there is an act of the Assembly. Okay. So, to my mind, in India, then
if I understood what you have said so far, the manner in which the referendum is done seems to be a middle ground between the way we look at something that emanates from the Constituent Assembly. So it's not constituent power, neither is it, what is the other?
No. So I'm trying to draw the comparison between India and Ireland, and I'm saying that the way I could see it was that in India we draw that complete, we see constitutional amendments as a midway ground. So it is not the Constituent Assembly that is bringing about the constitutional amendments, but neither is it seen as an ordinary legislative act, which is what like a number of cases have talked about. But in Ireland, what I understood is that if there is a referendum, we're sort of, and considering that the initial Irish constitution also came on the basis of a plebiscite, so what I understood is that we're trying to recreate that form of Constituent Assembly setting in bringing about any constitutional amendment. So does that sort of difference that is given to constitutional amendment in India vis-a-vis Ireland, is that right in my mind? Does that lead to any difference in how constitutional amendments will later be subsequently be accepted by the judiciary or in general interpretation? That's basically where my doubt is coming from.
Are you saying that one? I wouldn't contend that one process is more legitimate than the other, because I think that the Indian process is uniquely suited to the Indian situation. I just think it. I mean, you all know the situation here, but I think the idea of having a constitutional amendment for 1.3 billion people would be quite an undertaking. I mean, just to explain the way in which it happens in Ireland, I've talked to you about the way the Constitutional Commission works. It's normally chaired by a High Court judge. You have people there, both sides are asked to put in their material, both sides are asked to comment on it, both sides, it's actually carried out almost like a judicial process. And then material is disseminated to every person in the country. Every person in the country, or every house in the country. That's great if you happen to be a small country of 4 million. It's just not possible. So therefore, I think the measure of legitimacy has to be seen in the context of India's situation. And I entirely subscribe to and understand why Nehru would have decided that flexibility was necessary here.
Referendums, so the one problem was obviously that India is a vaster country, but like the other problem also was that people would not be aware of all the complexities that would be talked about in bringing about the law. Wouldn't that be a problem in Ireland as well? So I understand that Ireland population-wise is a smaller country, but when we're talking about the complexity of the law that is coming about, wouldn't that be a problem in Ireland also, and wouldn't that then raise a question about the referendum that is being brought about?
Would you want to link that with the whole argument about constituent power that we are making with regard to constitutional amendment? Is that where the question is coming from?
Yeah,
that when we talk about limitations on the amendment power, and the Parliament has drawn upon this idea of a constituent power, and we have said that no, we need to distinguish this amendment power from a constituent power, and hence there must be limitations on this power. Would that argument apply to a referendum as well? So does a referendum then, will it be seen as a manifestation of constituent power, and hence the limitations on it would be necessarily less, or it would be seen as constituted power and hence the limitations would be more? Would that be?
Then I would be seeing the referendum as constituent power through and through, whereas in India I would not see that amendment as a work of a constituent assembly. And so then to my mind there would be a difference in the kind of the degree of importance you're giving to the amendment per se in India as opposed to in Ireland.
Sure.
So the short question I suppose is the referendum power seen as constituent power, the original power to make the constitution?
It effectively is constituting, using the term advisory, the people are the legislators. It is a constituent power. And the only circumstances, I didn't go into it in any detail, but on one or two occasions subsequently, people have sought to challenge a referendum on the basis of saying, I don't know what I'm voting for, it seems very vague, or it's unnecessary to have this referendum because there is a provision already in law. This arose in the context of the Eighth Amendment, and the courts very resolutely said, no, we're not interfering, it's a matter for the people to make a decision. They're our constituent assembly, they're the people are the sovereign people. But I wouldn't want to try doing that in India.
Just so that I understand it better, it's a very good question. What if those people are not informed citizens?
Sorry, because all the air conditioning is on, it's really hard to hear. Sorry.
What if the people are not informed citizenry? Then how does it, I mean, I heard your answer that they are our constituent people, but what, I mean, that's what you're trying to ask, right? Citizenry is not informed. I mean, how does that impact the whole yeah, I'm just trying to understand it better, so I'm reframing the question.
How do you mean? How does it impact? Oh, sorry. In that sense. Well, what happens is every household receives documentation, pamphlets on both sides. There are broadcasts, about 8 or 10 broadcasts on TV on each side. Certainly in 1983, people sardonically commented that there wasn't a person in Ireland who didn't know about issues regarding reproduction which had never before been discussed in Ireland. In the McChrystal case and in the Jordan case which followed it, there were political scientists who testified about the extent of understanding of the issues, and the surveys post hoc showed that there was quite a high level so 80 to 90% understanding of the issues. Because of the fact that we're a small country, and because of the fact that there's a high engagement, for example, in watching TV, some TV programs, 1 million out of 4 million people, that's a quarter of our population will watch it. So it's much easier to achieve a deeper penetration in those circumstances. So do people understand what they're voting for? Yes, I think they do. However, I accept entirely that there are circumstances in which, in referendums, the people can be voting for something else. I'll give you an example. In 2009, we were facing a question of a further treaty to join to bring in further constitutional proposals regarding the European Union. The government of the day was extremely unpopular. They put up the proposal, and on the first occasion the people voted against it. And I think it's arguable, quite arguable, that in that they were voting more against the government than they were against the proposal. That caused consternation in the European Union, and Ireland went and we had a second referendum where the issue was put more squarely, and the people resolutely voted in favour of it the second time, as some people suggested, having got the anger off their chest the first time round. But it does, I mean, the Brexit experience in Britain does demonstrate that there are always risks in referendums. I totally agree. There are other risks too. There's a risk of misunderstanding or insufficient understanding. There's a risk of outside interference by interest groups either side. There's a risk of hidden funding. There's a risk of misportrayal. I completely agree with your view that there are risks, and I would imagine that we are going to be facing in the future at some stage some referendum on some issue where questions of the interference by large, well-funded outside organisations will arise, and that who are non-governmental. We have yet to have to deal with that. So could that arise? Absolutely, yeah. I mean, I'm not saying. All I can say is, hitherto the system has worked relatively well. Does that give a guarantee it works perfectly every time? No. And have people criticised the McKenna judgment? Yes, they have, because they've said this is the whole business of government is to govern. The minority in McKenna, the Judge Barrington, said this is ridiculous. What is it? What are governments to do but to put up proposals? What are they to do but to lead? And can they not use state resources for that purpose? So, are we dealing with an area which we're not dealing with an area which is uncontroversial?
Hello, sir. My question relates to the process of referendum for amendment. Now it's sort of what happens. My question relates to what happens post the amendment. So if suppose the particular society that voted for the amendment and the amendment gets passed, do courts play any role after it is passed in terms of determining if this is in consonance with the constitutional values? Or suppose if after a passage of a few years, the new society challenges the sensibilities which led to the passing of the first amendment a couple or like years ago, then what is the process then? So for example, at a particular time, society might subscribe to some values which would lead to passing of a certain position as an amendment. Now if those positions change later in time, then number one, do the courts play any role? And if not, then what is the procedure to be used to change that law?
No, the only way to do it is for the people. Once the amendment is passed, there is a procedure, very rigorous procedure, saying it must then thereafter be signed by the President, then it's law, and the only way it can be undone is by another constitutional amendment. The courts do not have a role, save in the context that I was discussing before. But there are very strict guidelines about the time within which you can challenge a referendum result. And once that trigger period has passed, and the matter is, and the proposal is signed by the President, then it's law, and the courts have no further role, apart from interpreting the provision, of course.
Adding to the previous questions that have been presented, my question would be the problem of a referendum that lies on a majority opinion. Now, in the recent privacy judgment, one of the criticisms of the cautious judgment that regardless of popular opinion, whether it is legislative or otherwise, courts have to protect the rights of the minorities. So in that light, in Ireland, what if there is some majority opinion or whatever? Wouldn't that mean that by default any amendment that comes into place disregarding any other opinion? Now, in that sense, can the Constitution be used to protect those minorities, or is the constituent people's voice going to be taken into consideration? How do you balance those interests?
That's a great question. As on our present level of jurisprudence, if a proposal is put and passed by the people, it becomes law. There's no protection laid down as yet in our jurisprudence. So I'm just thinking out loud. Do I think that there is a great deal of value in Indian jurisprudence in relation to basic structure and frameworks, protection of minority rights? I think there's a huge value in it. I have to say that frankly. Fortunately, we haven't been faced with that kind of situation. But thus far, we've been okay. We're lucky in the sense that our political system is rather stable and rather conservative. We're lucky in that we haven't been subject to the onslaught of right-wing populism that there has been throughout Western, Central and Eastern Europe. But is there a point of vulnerability? Yes, there is. But we have, whether fortunately or unfortunately, rather conservative population where 70% of people tend to vote towards the consensus. Could it go wrong? Yeah, it could. And is your question a valid one? Yes, it is. And we haven't yet had to meet that situation.
I just want an opinion on what the constitutional, the initial drafters of the Constitution of Ireland, why did they consciously choose to adopt this referendum process of bringing about constitutional amendments? What were the kind of discussions that took place in the Assembly at that time, and why was this conscious decision of having the amendments through the referendum process adopted by the Irish Constitution framers?
That's another great question. It was to do with legitimacy. And it was to draw a fundamental distinction between the way in which sovereignty, the diluted form of sovereignty which had been achieved in the Constitution of 1922, where the Crown and the Sovereign was still seen as being the ultimate enactor of legislation. If that had remained so, what was the Civil War about? What were the dreadful divisions about? So what the Constitution, the manner of enactment of the 1937 Constitution was to be an act of the sovereign people. And what it was by way of distinction from the Constitution of 1922, which was part of a actually part of a British Act of Parliament as well as our own, it was to be seen as a piece of, to use a phrase that I used before, self-conceptualization and self-realization, an act of national will. Of course, it has to be said that that was in the context of 26 counties, not 32, but it was to draw a line under all the events from 1921 up to 1937. One historian said that De Valera's enactment of the 1937 Constitution looked more to the past than to the future. And when you look at the principles of social policy, for example, the type of society which was envisaged was actually a very traditional form of society. De Valera in 1943 made a speech where he talked about his ideal Ireland, where couples could dance at the crossroads and that comely maidens would dance with handsome young men. It was a very rural idyll that he was proposing, and in some ways we remained stuck in that until the late 1950s. Ireland became a very static society. But what was about legitimacy, and an act of sovereignty, democratic sovereignty?
Ma'am, so excuse me. So when we talk about locating the law in the Constitution, I have a problem because see what my understanding of comparative public law is that it consists of those principles which have been developed through the courts and those which have achieved universality. Right, and Constitution for me is a place where these principles have been laid down and you cannot contaminate these principles, right? Like suppose even in India we have a concept of secularism, but what secularism actually means is something we cannot define in the Constitution because Constitution is an evolving document and it can have different interpretations for the generations to come, and therefore when you say that we are looking at Constitution to find law itself, don't you think that will create a problem in a longer run? That is one question. And secondly, ma'am, I have a problem in basically accepting the principle of bricolage to understand the comparative public law, because as you are correct, because what I understand is that this principle is devoid of its social context, because it doesn't take into consideration what the social background, because I cannot take the document or an understanding of particular principle from a different common law or a civil law jurisdiction to understand what its application is in the particular context or social context of India. So what is your view on that? Thank you.
Don't know. In relation to secularism, I don't want to, I'm reluctant to comment on an Indian situation because I think Indian people understand it much better. And there's nothing more irritating than outside commentators coming along and saying, well, I think India should do this or that. I think that there is, I'm speaking more generally, I recognize there, and we were talking about it last night, there's a real difference between, say, an Irish situation and a situation like in India, because values which you seek to protect and a court seeks to protect in an Indian situation would be, in my view, really rather different from those in an Irish situation. And if you contrast it with the United States, where there's a wall of separation, you're familiar with the idea of a wall of separation. That is, the United States Supreme Court simply will not engage with what are called religious issues. I could readily see circumstances where, on the basis of the constitutional provisions in India, a court might say, well, we've not only a right but a duty to protect minorities. So that's very different from a wall of separation.
If I can answer that question, one, to start off with your second one, is bricolage necessarily acontextual? I don't think so. I mean, if you look at the obvious connection of directive principles, for example, I don't think it was borrowed without a context. And I think it was a very deliberate effort to, on the one hand, have the fundamental rights and have the directives. And so it is an effort at bricolage in that sense that you're borrowing from very different places and you're trying to construct something when you're looking at different places. I don't necessarily think that even Tushnet refers to bricolage as an exercise in randomness, but it is an exercise that you must recognize is borrowing from very different places, and perhaps in its creation is looking at a completely different idea. So for example, the way in which the directives have rolled out in Ireland and the way in which they rolled out in India is so different, although we have explicitly borrowed that particular aspect from the Irish Constitution. We have not interpreted or used it in the way in which that Constitution has used it. So this is one thing that he's asking us to look at. But with regard to the first one, which is that locating law in the Constitution, yes, I agree that for students of comparative public law, this becomes very difficult to accept. That, so what happens in countries without a constitution, not without a particular constitutional document, where then are you going to locate the law? And when you say locating law in the Constitution, are you looking at constitutional text, or are we saying that there are constitutional values that you then try and locate the law in? So yes, this particular aspect of locating law in the Constitution is not as simple as it seems, it's not as obvious as it seems. To take an Indian example, in the case that's been recently overruled, ADM Jabalpur, I think is a very good example of saying that the text of the Constitution did provide for the suspension of fundamental rights. But the minority opinion, which has now been reiterated, is that the way in which you could have looked at the text of the Constitution, that already, although Article 21 could have been overruled, the concept of rule of law is not something that is explicitly located in 21, and hence that does not get suspended by the declaration of emergency. So here again, are you looking at the text of the law? Sure. Are you locating it in the Constitution? Sure, but you're not locating necessarily in the constitutional text in the same manner in which the majority in ADM Jabalpur understood it. So that's something that we can think about.
Also, I think that from my point of view, engaging in this process has shown me the extraordinary importance of the need for complementarity between courts and the academy. I'll give you examples. Just by coincidence, last night I was Googling issues and material for today, and I saw a speech delivered by one of my colleagues talking about the risks of the citation of authorities in a decontextualized way. The citation of New Zealand authorities, the citation of authorities from all forms of jurisdiction. And what he was saying, and he was saying it on the basis of experience, was that these were being totally decontextualized. But the difficulty is that you might have a disparity of legal representation. You might have people who engage in a much deeper form of research on one side than the other, and scholarship evens out the balance. Scholarship is going to have the effect of reducing the risk of decontextualization, because scholarship looks at it scrutinizes the process. It looks at the process whereby comparative jurisprudence evolved. It sets out a methodology and it redresses the balance. The person who was speaking was then my ordinary colleague in the Supreme Court, and he's now Chief Justice. So it's a worry. It's a real worry, and this is why all of us as lawyers are going to be facing it more and more in the future, because it's very, very easy to produce a citation from the United States and say, hey, look, the Supreme Court decided that. But you have to ask, as I said before, you have to ask about the legal context, but also you have to look about what place does it take in the body of legal jurisprudence. Was it one decision? And there might be 10 other decisions, both before and after, which considerably nuance it. Or you might even find that this is a decision which had been reversed. So it is a completely dishonest procedure. So this is why the process is so intensely valuable. And the more I've done it, the more convinced I've been of why this is an important thing, which I think every law school should be doing much more of.
So the question relates to the amendment of the Ireland Constitution. So we see that the constitutional amendment per se are not challengeable. There is no judicial review except under Article 26, where the President can refer it for the judicial scrutiny. Now, does there not exist any bias in favor of state? So if a minority segment of if the minority people want to challenge the amendment, they cannot. But if the state wants to challenge, they can.
Well, the way in which Article 26 works is it's a matter entirely for the President, having taken advice from the Council of State, and it's entirely a matter within his or her own discretion. And speaking for our President, he's a most independent-minded person. So it's it's actually a method of redressing things. There's always a risk in the Article 26 process, let me be honest, because what we have to do is look at every contingency. And there's always a risk once you actually say that an act is constitutional, that some case comes along afterwards and you say, wow, if we thought of that, maybe we would have looked at that section in a different way. So are there hazards in it? Yes, there are. That's why there is a great deal of care taken before anything is referred to us under Article 26, because it's a blunderbuss, or rather, more accurately, it's a sledgehammer, because once an act is declared constitutional, that's it. And the only way to remedy the situation is to have another referendum.
Good afternoon, sir. Sir, I have a question, please. Given that the referendum... Okay, sir, given that the referendum has been done in a free and a fair manner, but still it's a game of numbers and propaganda. For example, in Turkey, the President Erdogan has used it as a political tool for undemocratic purpose. So why are the court more hesitant in invoking the basic structure doctrine for the judicial review in case of a referendum, but easily agreeable in case of legislative amendments? Thank you, sir.
All I can say is we've been very lucky. The only proposals that there were, fortunately we have a very, very contrarian population. For example, we use a form of proportional representation to elect our representatives. And during discussions with Sir Benegal Rao in 1946, our then Prime Minister Eamon de Valera said he regretted having proportional representation because it doesn't allow for a proper majority. And on a subsequent occasion, he tried to put this to the people in an effort to change the voting system so that it would be a straight vote. Now, a straight vote would have allowed for a much stronger government, one way or the other. And our electorate said absolutely not. It was rejected out of hand because they liked to keep their representatives precisely where they were, under their finger. Does it give rise to a degree of clientism in our politics? Yes, it does. Does it give rise to dealing with local issues at the expense of broad national issues? Yes, it does. But the attachment of the electorate to proportional representation is considerable. So the people seem to be very alive to any attempt by anyone to take away what they consider are their rights. It's very deeply embedded in our culture, and the extent of interest in politics is illustrated by the fact that on the count day of an election, 600,000 or 700,000 people will be watching each process of the count, and it says something about our psyche that that Irish people like politics. They're engaged in politics in a very serious way, and I suppose that's demonstrated in America as well, where Irish people who went to America seem to get involved in politics. So I don't think there's a risk. Are you right to ask the question? Yes, you are. But we haven't been faced with that. We haven't been faced with any form of right-wing or left-wing substantial popular movement which would try to oust constitutional values ever. May happen, but I don't think so.
Sir, so when you spoke of the constitutional amendments, so one of the major purposes of a constitutional amendment that can be seen from the face of it is that it gives a kind of legitimacy so that the government can act. So or else the government can merely say, I have the numbers, I have the support, I can act. So there's a difference between acting with legitimacy and acting merely because you have the strength. So one of the purposes of a constitution is to give a framework within which the government...
Can I repeat what you have said and you let me know if you've got it? I think he's answering that question in terms of referendums and legislative power to amend the constitution, right? What happens with majorities in parliament when they pass amendments is that they are using their numbers, their strength, which has not been given for a particular mandate, but it is a general mandate which has been given, which they are using in terms of constitutional amendments, and a referendum in which whatever may have been the general number, which has the general strength of a particular political party in power, the referendum will seek a very specific mandate for that particular purpose, and irrespective of what the general mandate is. And so there is a difference between the general mandate and the referendum which requires a specific mandate. That's the point you're making.
No, it's a problem I have with the very understanding of a constitutional amendment.
No, is this correct in terms of your distinction between general number strength and specific referendum? No.
No, I'm not going with the question of a referendum or changing it through the parliament. So my question is more about the constitution gives the framework within which the parliament can act. So within which the government can act. So if the parliament or the government says it is my wish to decide what is the framework, so does it not strike at the legitimacy of the government in place or the parliament in place? Because that now becomes very much akin to what we mean by might is right. So a constitution gives a framework within which the parliament can act, and the parliament derives its legitimacy by saying that, look, we are acting within this particular framework which is given to us by the constitution. Now if the parliament says, I decide what the constitution is going to be, so does it not strike at the very legitimacy of the parliament? And the second question I have is so it's not a question, it's more than kind of a question. So does this not give the judiciary the legitimacy to say what the parliament is doing is wrong? Because when we say, even if we say they are representing the will of the people, what we understand is it's not the will of the people, it's just that the government making a claim that we know what the people want.
I'd like to think about those questions. I'll come back to you in a few minutes because they're interesting questions. Yeah.
So one comment and one question. The comment is that when we look at the comparative debate on judicial scrutiny over amendments, obviously the extent of scrutiny has to be closely tied to how easy or how hard it is to amend the constitution. Okay, can I be heard now? Right. So when we look at the comparative debate on judicial scrutiny over amendments, and there's some interesting work by people like Gary Jacobson, who've tried to document countries where courts have actually started exercising scrutiny over amendments. But the first logical question to ask would be that the extent of judicial scrutiny over the amendments are also closely tied to how hard or how easy it is to amend the constitution of a particular country. And in that sense, at least in the limited reading I've done, I found that many comparative scholars get excited about the way in which Indian courts are talking about the basic structure doctrine, but they don't really account for the clear political circumstances that led to the application of this doctrine. For instance, it came up in the presentation today also, that very often we assume that judicial scrutiny over amendments is an extended form of the courts performing the counter-majoritarian function. But if you take some of the important basic structure doctrine cases in India, you'll actually find it's an example of the opposite phenomenon. Because the amendment process was easier to use, so even a transient majority perhaps, or even a coalition, can push through an amendment, which may not actually reflect the kind of assumption that you make about a supermajority. So on paper it looks like the amendment should reflect a supermajority, but in effect, if you account for the political circumstances surrounding a particular case, you may find that courts are actually standing up for the popular majority in some scenarios. So this is something I found it's a common mistake in many of the comparative, much of the comparative work that is being done on the basic structure doctrine. So that was a comment. The pointed question I have for you, Justice McManaman, is that on the idea of constitutional moments, which scholars like Bruce Ackerman have proposed, they have come up with an alternative frame for looking at constitutional change. And their argument, as I'm sure you're familiar with it, is that in constitutions where formal amendment processes are difficult, it's more likely that there would be a deep period of turmoil which leads to a certain consensus that defines long-lasting change. So in his books, especially the book We the People Transformations, he concentrates on the Civil War and the New Deal as two periods where distinctive changes happen to American constitutional law despite not many formal changes in the text. So in your view, if you want to look at the idea of constitutional moments as one way of thinking about constitutional change, how would you juxtapose it to, let's say, the Irish experience, where the power to initiate an amendment is clearly with the popular measure called a referendum? So would you find similarities there, or do you think they are completely conceptually different claims?
The funny thing is, if you look at all our constitutional referendums, I can't think of anyone where I'd say I think the people went mad. Not one. You know, you can understand each one of them. They make sense. Perhaps we've been very, very lucky because none of the constitutional amendments which we've had, save and except perhaps the Eighth Amendment, has moved outside the norm of what might be anticipated. There have been a number of referendums in relation to the European Union. Two of them, it's fair to say, were in the case of one treaty called Nice and also Lisbon. On both of those occasions, the electorate said no and then voted yes again afterwards. We don't seem to have constitutional moments. We have constitutional hours, days, weeks, and I think perhaps we're fortunate in that. Why that is, I don't know. I mean, I'd need a political scientist to help me work that through. But we're just fortunate, I think, so far. But the experience of Europe, what we were talking about yesterday and talking about elsewhere, does give you a pause. Democracies in Europe, which were thought to be well established by the 1990s, suddenly became fragile. It's always a haunting thought, because you say to yourself, I never thought that could happen, and yet it did, and it happens incrementally, bit by bit, and suddenly within a year, the whole fabric has changed, one election. But we've been lucky, and it might be to do with what we were talking about at the very beginning, the extent to which our electorate are fundamentally 60 to 70% conservative, kind of property. They have a property owning mentality, and consequently, maybe it is they're less likely to be swayed by issues which, in a different situation, could like Germany in the 1930s, where there's extreme desperation, then I can see that that there could be a constitutional moment. The only time we came close to constitutional moment was in the last 4 years, where we had this very serious recession. Then there were moments where you felt things could really go pear-shaped. But we were lucky because we have an administration. I'm talking about our tax system. Greece, not everyone will know about Greece, but poor Greece is in a situation where their tax collection system simply doesn't work. That people who claim that they're very poor mysteriously have swimming pools in their gardens. That no house, that there are very many houses that remain in a state of non-completion, because once you complete the house, then you start paying extra tax on it. There are a great number of people who don't pay any tax at all. But what we have, fortunately, is we have a tax collection system that worked, and it began to work effectively when we introduced a thing called VAT, value added tax, which I think might be a little bit similar to what has just been introduced here, because it prevented people from evading tax, because every transaction, not only was there a tax on every transaction, but professionals were also subject to the VAT, and therefore everything they did was subject to scrutiny. We were lucky. We were lucky.
Are there any other questions? Do we have any other questions?
In follow-up with what Shivaraman was saying, it's a comment saying, when you say where does the Supreme Court or the judiciary gets its legitimacy to act or to sit in judgment over democratic decision making, so if we take it in such a way that democracy is unnecessarily majoritarian, and therefore there would definitely be unheard voices even within the democratic structure, and therefore like we say about, if I may take a story which is often taken as a criticism to utilitarian arguments, wherein if you take the example of a small kid locked up in a room for the betterment of the whole society may stand against the individual freedom of that particular kid, but if the same case comes to the bench of a court, it must hold in favor of the individual freedom of that particular individual. And in connecting to that, it's a different question in the sense that when we talk about unconstitutional constitutional amendments, we are talking about Parliament making an error in understanding the constitutional values. So when a judiciary is exercising a judgment over it, one thing is it must have to exercise such a judgment in abundant caution, because when the Parliament errs, it's a collective failure, but when the judiciary errs, it is not. And when we talk about unconstitutional constitutional amendments, we should also look at a scenario where we can see unconstitutional judicial pronouncements. Because if the Parliament errs, there are ways we can have a recourse, but when the judiciary errs, it is not. So if we just take the case of the judicial appointment case and the whole things that follow, every scholar, legal scholar feels that there is many things unconstitutional about the way judicial appointments is made through the collegium system. But it remains just because the court said so. Supreme Court says is the law of the land. So the court should take abundant caution to ensure that court should not grow beyond the constitution itself. So
appeal. When you say we have for judicial error in the High Court, obviously we have a system of appeal to the Court of Appeal on a point of law of general public importance. It comes to us if it's in the interest of justice, because the law needs clarification, we will allow it to come to us and we make a decision on to clarify the law. So that's our remedy for judicial error in that sense. If we make, Then, I mean, there's another level as well, of course, because in the context of European law, if an issue of European law is put before us, there's a procedure whereby we can refer the matter to the European Court of Justice for their preliminary opinion on the issue, if it's necessary for the determination of the outcome of the case. And then the European Court of Justice will express its view, and then it comes back and we are bound by what they say. So there are levels.
But a referendum will also be done to rectify judicial error, isn't it?
Theoretically, yes. It's never happened. No, it's never happened. I suppose in one sense, in one sense there was, yes, there was one. We made a decision called Maguire versus Arda, M-A-G-U-I-R-E versus Arda, A-R-D-A-G-H, and we concluded that when our Parliament was carrying out an inquiry, that it was not entitled to make findings of fact, because we said that was a function for courts. And this, in the eyes of the Parliament, what the background was that the Parliament had embarked on an inquiry. The inquiry, well, the evidence disclosed that the inquiry was being conducted in a skewed way, a biased way, that the deputies who were in our Parliament were asking questions which would tend to indicate that they had a viewpoint. So that meant there were going to be both judges and also commentators. And my predecessors in the Supreme Court said that if you're going to find facts in that way, you're acting in an almost judicial fashion, and therefore you must act in a manner which does not display any objective bias. Politicians find that very hard because they're being asked all the time to comment on things. There was a referendum 4 years ago, effectively to reverse that judgment, but it failed because I think because the public trusted the courts a little bit more than they did the politicians. There were strong views about that case because it goes to the whole question of separation of powers and the extent to which we in the Supreme Court can interfere with the role of the legislators. The legislators say, you're coming into our territory, you shouldn't be doing that. We, the courts, were saying, you're carrying out the procedure so unfairly that if you would insist in carrying out inquiries, you have to almost do it in a judicial fashion. And the judgment said effectively, well look, the Americans can do it without, or used to be able to do it in a fairly judicial fashion. Why can't you? But that was the one effort to reverse a judgment, and it failed.
Are there any further questions? No? So we will continue with the theme of looking at rights in the context of comparative constitutional law for tomorrow. So you can look at the readings under Module 2, and we'll meet tomorrow. Thank you.